Good afternoon, everybody. My name is Michael Freeston. I'm Director of Quality Improvement at the Preschool Learning Alliance, and I'm joined today by Lisa Graham, Lead Safeguarding Advisor.
Hello, my name is Lisa Graham. I'm the Lead Safeguarding Advisor with the Preschool Learning Alliance.
Thank you, everybody. Our topic today is safeguarding related in terms of recording and transferring information procedures. It's one of the elements, as soon as we have any topic to do which has safeguarding in the title, it becomes immensely popular because obviously our primary concern at all stages is to ensure that the children in our care are safe. But one of the areas that is often picked up by Ofsted in the reports is that actually the recording of safeguarding incidents or any activities is not necessarily as effective as it should be, and often leads to downgrades in Ofsted inspections, and I'm sure Lisa will pick up on that today. So it seemed a sensible and informative session to just spend some time refreshing practitioners' identification of the importance of recording effectively any safeguarding incidents, but also the reasons as to why and how that can best be done. If I just try and click through the slides. So we have two topics of focus today. Why does safeguarding recording matter? And what are the requirements about sharing information? Obviously, as I'm sure you're all aware, there are recent forthcoming developments around information protection, the general data protection regulations coming in May of next year. But it's important that we also refresh our memories about what the current requirements are as well. So, for those of you who are new to webinars, don't be afraid. They're basically the same as a normal seminar, but are on the web, which means we're in a far easier position to get to many of you across different parts of the country, rather than all coming to one particular place. We generally work to about a 15 to 20 minute presentation, although I think today's might take us a bit longer than that. And then we allow time for questions and comments. But I would urge you please to type into your toolbox using a keyboard the little box that says questions at any time. Whenever a thought or a question comes to you, please do type it straight through. Don't wait to the end, because my role in the chair's position is to try and filter those questions seamlessly into Lisa for answer as we go along. So please do make your points as they arise to you. So that's the control panel you should see, and you can type in there. It does say you can type them in German, Spanish and French. Please don't, because we won't understand them. So without further ado, I shall hand over to Lisa to talk us through.
Hello everyone. So what we wanted to look at first of all was about why safeguarding recording matters, and obviously we need documentary evidence of the work that we do with children and families, so we do need to be able to keep a record of the work that we're doing. We also need to be able to show how we're keeping children and families safe, and so that would be in instances such as if a child disclosed, or if there was a concern about a child potentially being neglected. And we also need to demonstrate that we're meeting regulatory requirements. And so, for instance, Ofsted would need to know that we are recording our administering of medication thoroughly and in a timely fashion as well. Potentially, we have to share the information that we record about children and families. So if a local authority was doing a Section 47 safeguarding investigation, they could ring up our settings, and we would have to give them a summary of what safeguarding and welfare concerns we had, if any, in relation to that child and family. And in the event that a child becomes involved with the local authority due to concerns about the parent's ability to look after the child, potentially we'd be asked to contribute to family courts as well. So we'd have to take the recordings that were made and summarise that into a report for family court. So really, we're a key agency as early years settings. We are a key agency with relevant information linked to safeguarding and welfare about all of the children that we work with potentially. We need to, when we're making a safeguarding referral, we need to show what the outcomes are as well. So we're looking to see the story. So what we would want is that if we've made, for instance, a referral to early help, we would need to see how that was followed up, what the outcome was, what the actions are. So we're looking to see outcomes and the story in relation to that safeguarding and welfare concern about a child. We've got to also ensure that any decisions that we make in relation to safeguarding, if we make those decisions in supervision, we need to ensure that they're also recorded on a child's file. And also, in some circumstances, we have to share information with other agencies. So, for instance, if a child was attending 2 early years settings, there'd need to be arrangements so that information could flow between the 2 settings. Similarly, if a child leaves an early years setting to start another, then in relation to safeguarding and welfare issues, there would need to be a flow of information between the settings about that. There have been some, in serious case reviews, there have been some scenarios where early years settings have been criticised in relation to their insufficient recording, and other agencies are also frequently criticised. There seems to be problems with sharing information between agencies in relation to serious case reviews. So the other thing, it's really important that everything is recorded. So in one serious case review, there was a comment that the school nurse had advised that she'd made repeated attempts to contact children's social care. But it seems that these attempts were not always recorded in the social care records. So what we had there was social care not having recorded these attempts, and that the school nurse had made to contact children's social care. So we do need to be very careful that for all of those instances where we try to contact another agency such as social care, that we make a record of it, because if we haven't got a record of it, there's absolutely no guarantee that other agencies will have a record of it.
Just on that point, Sarah's typed in a question, are we only talking about serious reportable incidents here? I noted your point earlier on, thank you for your question, Sarah. I noted your point that we're talking about the child's journey here, so presumably it could be anything that we have identified with a particular child.
Yeah, the focus of this webinar is about recording in relation to safeguarding. So, but I would say that would be safeguarding and welfare concerns generally. So not everything would be reportable. For instance, you might be concerned that a child might be showing some sort of indicators of neglect. It's unlikely that you would instantly report something like that the first time it occurred. What would be more likely was that you'd need to record it and you'd need to monitor it. So we would be recording all of our observations. So something like a child attending a setting with a very dirty lunchbox would be a cause for concern, but it's not likely to instantly lead you to make a safeguarding referral. So those sorts of things we're focusing on in relation to this webinar. It wouldn't always necessarily have to be something that was reportable, but we're not talking about learning journeys as such.
Okay, thank you for your question, Sarah.
So,
not gone too far.
In terms of just some more observations, really, from some very recent serious case reviews. One nursery actually had its registration suspended for a period of time because Ofsted were concerned about the level of recording after a 2-year-old girl unfortunately died. What had happened was that the child had attended nursery twice in the week before she died, and twice she had some level of facial injury to her face. The first instance, nursery had recorded a very poor, inaccurate account really of what the injury was. but they'd also spoken to grandma, and grandma had said she didn't know how this child had got that injury, and the nursery accepted that at face value and didn't chase up at all.
Oh right, so there was a requirement on the part of the nursery to pursue that to their satisfaction, rather than just taking the grandmother's word for it.
Well, the grandmother's word was that she didn't know, so the inference was that not knowing wasn't a good enough reason for the injury. If it was, does that make any sense?
Yes, absolutely.
Yeah. So on the second occasion that the child had attended, it was the day before the child died, and when after the child had died, there was a post-mortem, and what was found was that because the nursery's recording of the facial injuries on both instances was so poor, they couldn't, when they were doing the post-mortem, they couldn't work out if this was the same injuries that the nursery had seen, or if there were different injuries. And I mean, the quote, this is taken from the serious case review, this report. It said, the recording of the injury was woefully adequate for a number of reasons. It wasn't dated. It didn't describe the size, the location, or the colour of the injury. The record was entered by the maternal grandmother, and there was no conclusion as to how the injury had occurred, or what investigations had been made to conclude this. And when the serious case review also unpicked that this nursery had an approach where family members signed the book, and when children had an accident, and there was never any consideration that the injury might have occurred from the child's family. It seemed to be very much an exercise that the nursery had incorporated to protect itself from, rather than from being accused in relation to injuries, rather than a system which explored the possibility that a child might have been injured within the family environment.
Thank you.
Yeah.
So,
yeah. So in terms of, there are generic principles about how to record well in terms of safeguarding. So the first principle is that recording needs to be accurate, and it needs to be fair. So when we're recording, we need to express what the facts are, and we're supposed to make it clear and differentiate between a judgment, an opinion, or a hypothesis, and we're supposed to avoid making unnecessary or irrelevant judgments in recording. So recording's got to be a precise record, and it's another reason why we say that recording should always occur promptly. Really, recording should always be done by the next working day. That's best practice.
Sorry, Lisa, I've just had a note from Karen. I think it's relevant to the first point about accurate and fair.
Mm-hmm.
Should it not be written by the person who's involved in the action? Because how can that person be as objective as necessary to make accurate and fair reports?
Normally, recording should be completed by the person who is undertaking the intervention.
Right.
So if a family support worker has done a family support session, normally they should record that session.
Right.
In terms of completing an injury, normally it would be the person who spoke to the parent who observed the child. In earlier settings, that is actually often the designated person. Right. So everybody is, we are all accountable in terms of recording, but normally it would be the practitioner that had sort of lead responsibility that would do the recording. So, yeah, if there's going to be a report submitted to court, then it might be that the most senior person in the organisation or in the setting would make reference to all of the case recording that other people had already recorded and pull some of that together in the court report. But normally it should be the person who has had the intervention with the child.
Okay. Thank you, Karen, for your question.
So recording needs to express what the facts are, and it's much better to try to describe facts. So if you were, for instance, if you were a social worker undertaking a home visit and you had concerns about home conditions, it's much better to be accurate and descriptive in relation to what those conditions are. So it might be that the bin was overflowing with empty cans of alcohol, or it might be that the cigarette, that there was an ashtray which was overflowing in the living room and the bedroom. It's better to be absolutely accurate and to try not to make any judgment,
yes,
or to be careful about the tone of recording, because what you need is a neutral, fair tone, really, and just trying to describe things as they are, rather than put your personal judgments
right,
in relation to what it is that you say.
but I suppose there's a certain point that even the fact that you've noted it is an implied judgment on.
Yeah.
Yes.
Yeah, absolutely.
Okay,
Yeah.
thank you.
So recording needs to be clear. It's better if you can use straightforward language rather than acronyms. And I'm a social worker, so I love the use of the word appropriate, but I know it's actually a bit of a cover-all for everything. It needs to be concise as it possibly can be. It needs to be contemporaneous. The other thing is that recording is supposed to be proportionate and relevant and necessary for organisational purposes. So it would be noteworthy and acceptable to record a concern about housing conditions. It wouldn't be necessarily acceptable or noteworthy to record an opinion about decor.
Right. Okay. Yes.
So it needs to be relevant,
okay,
basically. Okay, and to distinguish between fact and opinion.
Okay. I've just gone ahead of you, and I've seen this is actually pretty much your answer to Karen's questions, as you said.
Yeah, so all practitioners who record are accountable. We're all accountable for those things that we write down on files. It's got to be compliant with legislation. It's got to meet a high professional standard. Our childcare provider records, they can be used in a court of law, and potentially they could be used to help a family court judge decide whether a child will be removed permanently from the biological family, or to make a decision about what type of contact a parent should have with a child moving forward. So it's the types of things that we're recording are really important, and that's why we've absolutely got to get it right and be scrupulous and robust with our recording. And also the recording potentially will be shared with other agencies that we've talked about. So our recording could be shared at initial child protection conferences, at strategy discussions, and recording also should evidence that justifiable safeguarding decisions have been made. So what we're looking is that if somebody external came in and looked at a record, they would be able to understand why we made the decisions that we made, or why we took the action that we took. So they wouldn't necessarily need to agree with it, but it would need to be justifiable.
Okay, thank you.
Okay. So we need the basics in terms of recording. So it needs to say what happened, when did it happen, where did it happen, who did it involve, and how did it happen. And many practitioners do very good work, but the reality is that if something isn't recorded, as far as external agencies are concerned, then it didn't happen. So
I think it's important that is seen as highlighted there, because that's the root of it, isn't it? If it isn't recorded, it didn't happen in the eyes of any legal situation or any evaluation.
In the eyes of Ofsted or a serious case review, or even a senior manager in an organisation coming and looking at the file, if it's not on the case file, as far as everybody's concerned, it didn't happen. So it's got to be there. So in terms of safeguarding work, you should be able to look at a file and know what work is being undertaken, what plans it links to, what assessments it links to, if there are any assessments, what are the roles of your agency and the other agencies. And it should show follow-up and continuity. So, for example, if a call is made to a social worker and they're unavailable, the next recording should show how it's followed up. That should be the end of the story. And the other thing that we're looking for in recording is to see the voice of the child really in recording, for it to be child focused, because obviously in terms of safeguarding, our our job really is to do with thinking about what the life is like for that child, what's the experience like for that child. So we would hope that recording should show some of that in terms of what it's like for the child. So you would need to record liaison with other agencies, discussion with other agencies, any agreements made, the outcomes of any meetings, assessments or plans. We also need to be able to look at patterns and to quantify risks. So we often use chronologies, which are sort of a concise summary of certain incidents that have occurred, and by compiling a chronology, you can start to identify whether or not there's a pattern of anything, and you can also look at risks sort of chronologically and cumulatively. So, for instance, if a child comes into a setting without a winter coat on one occasion, then you might just record it. But if the following day the child had shoes that didn't fit them, and the following day they didn't have any lunch, so you're looking at being able to identify where there's a pattern. And there are similar things in relation to risks associated with parenting. So if you have what all serious case reviews say is that we should all look at every new incident, but take into account all of the history that we're aware of.
Can I just bring in a question that Dawn has asked there, because I think that links quite nicely. Thank you for this, Dawn. She said, sure, this will come up later anyway, but a comment that safeguarding must also be about ensuring key staff are aware, and this might also need to be verbal. For all the reasons you've said, each of those indicators may have happened one day after another. And staff should never just record it and expect it to be read, bearing in mind confidentiality of child data protection, but also that the safety of the child being foremost. I think it's a really good point, Dawn, that whilst how much of that is actually just the discussion that takes place during the day between practitioners, and what should be formally written down by a key person in the formal log.
Absolutely, and there needs to be an understanding about how that works in practice and settings as well, and who records what. But certainly, you've got to have those discussions, and within early years settings, the early years foundation stage requirements are that there's a designated lead for safeguarding, so they do need to be aware of everything that happens. That might be a safeguarding concern. Certainly, staff have got a duty to tell them. But similarly, if the designated person has to be able to have things recorded and up to date as well, because in the instance that the designated person goes off on it unexpectedly, then somebody else needs to be able to pick up that information. Because what you don't want, and this is what happens sometimes, is that, for instance, if another agency makes a referral about a child, then the local authority will contact, say, the nursery to find out what their take is, whether they have any concerns. What you need is for them to be given precise, accurate, up-to-date information. You don't want them to be given information that's a month or two old that's got crucial bits missing.
It is a really delicate balance, isn't it, between the key person being the primary person for a recording, but also that person being given information that the other practitioners may not know is relevant to an ongoing journey with that child, but should have been spotted as well. Yeah. It is a really difficult thing. Thank you.
Absolutely, yeah. Oh, the other thing that recording sort of needs to show, and I mean, you need to be having these actual discussions as well, is in every instance, if something new happens, we have to think about, has the threshold changed? So just, for instance, if something wasn't at the threshold previously that would have been accepted as a child protection referral, that doesn't mean that it won't be in the future. So at any point, anything can happen that actually means that that's changed now, and that we do need to go back and make, for instance, a child protection referral. And we've got to consider escalation as well. All of us now working together, is very clear that all practitioners and the designated person really have got a duty to escalate the concerns if they feel that appropriate action isn't being taken to safeguard a child.
Thank you.
Okay. So in terms of accountability, obviously, we are all accountable to the children and parents, carers we work for. in terms of we have to be fair about what we're recording. We're also accountable to the organisation that we work for. So the organisation has got a reputation to uphold as well in terms of quality. But actually we're also accountable to ourselves in terms of that we want to be perceived to be skilled, competent practitioners who've got integrity. And we are going to be sharing some potentially very serious, life-changing information with other organisations such as family courts, who can make life-changing legal decisions. So it's got to be accurate. Good recording promotes the safety of children, and it also provides a basis of evidence for future safeguarding decisions and activities. And it allows for continuity if a staff member is absent or leaves. And of course, it's also a fundamental requirement of the EYFS for all of us that work with children and families. So information sharing is governed really by 7 goals and principles. And the most important consideration is whether sharing information is likely to safeguard and protect a child. So we need to be, the Data Protection Act and human rights law aren't supposed to be barriers to justified information sharing. It's supposed to provide a framework to ensure that we share appropriately personal information about living individuals. And we need to be open and honest with the individual and their family where appropriate from the outset about why we'll share information, in what circumstances, how and with who we'll share it. And normally we would seek agreement to share information, but we wouldn't always do that. There'd be some circumstances where it would be inappropriate to seek agreement or it would be unsafe. So in terms of safeguarding, you're making a judgment about whether or not it is safe and appropriate to share the nature of your concern with a parent before you make a referral. For instance, if there was a significant crime, a child was disclosing that the parent had very seriously assaulted them, most local authorities would prefer that you make a referral rather than have the discussion with the parent first.
Yes, for example.
And local authorities will give advice to designated persons also if you're not sure about whether or not to advise a parent beforehand. So generally it's very good practice and we should be sharing information and seeking consent to share before we share it, but there are certain circumstances where we would be required to share the information with the local authority before if it might put a child at risk.
Okay.
And you can always seek advice from other practitioners if you're in any doubt. We're supposed to share with informed consent where appropriate, and as far as possible respect the wishes of those who do not consent to share confidential information. You can still share information without consent if in your judgment there's a good reason to do so, such as where safety may be at risk. So if you are genuinely concerned that a child might be at risk of abuse or neglect, that would be within the public interest for you to override a parent's reluctance to agree to consent.
One of the questions one of the interesting statements I always remember about safeguarding is where it said, no good safeguarding decision is made on your own. So, and that's a perfect situation. If you may feel as though there's good reason to do so, just have a conversation with your manager, with an informed practitioner about this, because these are serious issues. And so actually giving the opportunity to just share the consideration with somebody else whom you respect and is informed about these things can only be in everybody's best interest.
Yeah. And you need to base your judgment really on the individual facts of each case, and also your LSCB will have procedures and guidance in relation to this. So just when you are sharing or requesting personal information from someone, be certain of the basis upon which you're doing so. and be mindful that if you have consent, an individual might not expect information to be shared in all circumstances. And really it's about being putting safety and well-being first, and base your information sharing decisions on considerations of the safety and well-being of the individual and of others who might be affected by their actions.
I had a question from Helen. Are these going to be affected by the General Data Protection Registration change? General Data Protection regulations. Thank you. These are principles, aren't they? So I can't imagine these will be affected.
These are principles, so I don't think that they're likely to be affected. The General Data Protection Regulations are supposed to be aimed at strengthening the current guidance, really, in relation to information sharing, to enable it to cope with the digital world.
Right.
But some things they are going to tighten up on. So, for instance, parents children are going to be able to request that they can have images of themselves removed from computers that parents have shared. So there are some significant changes for early years organisations. What we will need to be doing, really, I think, potentially, is reviewing our consent agreements that we have with parents about sharing information.
We have done a webinar specifically for members of the Alliance on this. I'm not sure if it's available on the YouTube site yet, but certainly is due to be in a very short period of time. So thank you.
The Information Commissioner's Office has got a bit more the useful summary of what we all need to do to prepare for the GDPR.
Moving us on.
Okay, so in terms of other principles, recording is supposed to be necessary, proportionate, relevant, adequate, accurate, timely and secure. So if it's not necessary, we don't need to keep a record.
Who decides what's necessary?
Well, you've got to use your judgment.
Right.
And when I'm thinking about recording, I imagine how I would feel if I was reading it about my child, right, which is another reason that I say we've got to be careful about our tones. So it's all right to be accurate. It's better not to be judgmental, right, in terms of recording. But also external people such as Ofsted potentially are going to come in and look at recording, and in the event that a serious case review occurs, then case files will have to be given to other external agencies to be scrutinised. Okay. So proportionate. I think we've sort of argued all of those things. Secure, obviously, we're all increasingly aware of the need to keep information secure. Okay. So, and in terms of information sharing, the other thing to say is keep a record of your decision. So whether you've decided to share information or whether you haven't, make a note of it and say what your reasoning was and who you talked about that with. Okay. In terms of information sharing, the bottom line is that if a practitioner has got concerns about a child's welfare or believes that they are at risk of harm, they should share the information with the local authority, children's social care, or potentially the NSPCC in certain areas. And if it was a very serious matter, potentially the police also. But local authority, children's social care have to be contacted if somebody genuinely has a concern that a child might be at risk of harm. If there is a belief that a child is or may be at risk of significant harm, then information can be shared without consent, especially if seeking consent might pose a risk to the child or if an offence has been committed. And it's good practice, even if the significant harm threshold may be reached, to seek consent, but not if it might jeopardise a child or place them at risk or interfere with police investigation. For a referral for early help, consent is usually sought in almost every instance. But local authorities have different protocols for early help referrals, so you do need to know what your local children's safeguarding board protocol is in relation to early help. Okay, client access to records. So the Data Protection Act gives individuals the right to view material that is stored about them. In early years settings, obviously, a 3-year-old a baby or a 4-year-old is too young really to make an informed request to see what's written about them or indeed to understand it. So usually the parent has got the right to request to see the information on behalf of the child, although technically the information does belong to the child. So we need to follow careful procedures to ensure that third-party information isn't disclosed, or that there won't be any detrimental effect on the child or others through the sharing of information with parents. So, for instance, if a child is disclosed in relation to a parent allegedly assaulting them, it would be worthwhile seeking legal advice or guidance about should this be shared in full, do parts of it need to be redacted, and also this might need to be reviewed in response to the GDPR changes, the sort of client access to records.
I've just had a timely note from a colleague as well saying on the GDPR we've also produced a mini guide as available for members as well, and that should be available on the website as well. So thank you for that.
Thanks very much. So we've talked about this briefly already about the transfer of confidential safeguarding records to school or other settings. So obviously parents or carers should have been made aware what information will be passed on to other settings and organisations, and they should have given their informed consent to this prior to a child starting to attend the setting. So we need to be honest with parents from the outset about what types of information we're going to share. The receiving school or setting will need to have a record of concerns, any safeguarding or welfare concerns that were raised in the setting and what has been done about them. And there are different retention periods that information should be stored about families according to what type of service they have. So, for example, a looked after child, information should be stored on for a very long time. If a family has no involvement, then we don't have the right to share any information and to store information. So information has got to be shared and stored and archived and destroyed in line with various statutory guidance.
Where do people find out which is the relevant piece of statutory guidance?
Most LSCBs have procedures that are online now that state specifically what types of information should be retained for what period of time. So child protection referrals would normally be retained until a child reached 25 years of age. CAF, early years child in need referrals, should be retained for 6 years. Ofsted expect us to retain children's records for a reasonable amount of time, which in practice is usually taken to be 3 years. And obviously anything that's reportable, such as to widow or any reportable death, injury, disease or dangerous occurrence, should be retained for 3 years after the date of the incident.
Sorry, I didn't click onto the slide. I thought you were doing all that from memory. Thank you.
And then it's just, obviously recording is a key part of the EYFS requirements, and what the Early Years Foundation stage says is that providers must maintain records and share information with parents, carers and other professionals working with the child, the police, social services and Ofsted to ensure the safe and efficient management of the setting and to help ensure the needs of all children are met. And providers must enable a regular two-way flow of information with parents and carers and between providers if a child is attending more than one setting.
Thank you. Sorry, just on that.
Yeah.
Thank you, Lisa. That's really helpful. And the point that sticks with me is that point around if it isn't recorded, it didn't happen. And how that links with the importance of effective supervision of staff in settings by their line manager, setting manager, whoever it may be. Because it's that point that the discussion about any issues concerning the child will be discussed, and would be an ideal point for any consideration of anything that's been recorded since the last supervision. So again, it's one of those elements which runs throughout all of the UIFS, that the importance of effective supervision that keeps the child at the centre of the process, whether it's about their learning and development or about their welfare, is essential if we're going to do good early years practice. Thank you for that. For those of you who are seasoned webinar attendees, you know that I generally don't. I don't keep going on unless there's any questions that come in. And Penny is just, please could you show slide 19 again? I was so busy typing I didn't realise it was a slide in time to. Right. This is the one that we're going to test you on at the end, Penny. It's the length of time that certain elements, certain bits of recording have to be kept. I didn't realise child protection referrals were until the child is 25. Don't panic too much about your typing, Penny, because, as I said, we make these recordings available to all participants and are available on our YouTube site, and so you can enjoy them again at your leisure. But I don't keep talking to artificially lengthen. If there are any other questions that people have which are pressing, please take a couple of seconds to say, Michael, don't stop talking, I'm writing, but my question is too long. Otherwise, it just remains for me to say thank you to Lisa for presenting about something which is often essential to what we do, but needs refreshing in our minds on a regular basis. That actually, if we're going to do evidence that we do safeguarding effectively well, then it all comes down to the recording and knowing how we treat that data. Thanks to everybody for their attendance today. I hope you found this session useful. It only remains for me to say have a good December and a good festive period when it comes. And we'll see you all in the new year. Thank you very much.